G'day everyone, it's Daniel. So, I've got another safety video for you, and this one is a little weird. So last week, the Supreme Court of New South Wales made a decision to effectively find that the Law Enforcement Powers and Responsibilities Act had an unconstitutional provision added to it. This provision was that it is illegal to protest in or near a place of worship. So a place of worship would be a church, a mosque, a synagogue, basically any place that's essential for your religion. Now, this action was brought by, effectively, the pro-Palestinian movement, who, obviously, I'm guessing, would like the right to protest near synagogues. So, the law was deemed unconstitutional because it limited someone's right to political communication. Here is the Justice and snippets of her decision.
Section 200. Subsection 5 of the Law Enforcement Powers and Responsibilities Act effectively burdens the freedom of communication on government and political matters. The implied freedom, which operates as a limitation on legislative power, has been described as essential to the maintenance of the system of representative and responsible government for which the Constitution provides. I am therefore satisfied that Section 200, subsection 5 is not reasonably appropriate and adapted to its legitimate purpose, being the third limb of the relevant constitutional inquiry. It follows that Section 200, subsection 5 of Law Enforcement Powers and Responsibilities Act is invalid. I will make a declaration to that effect.
Now, what this means in practice is if you are an event organiser organising a religious event, or otherwise you are in charge of a place of worship, if your risk assessment was trespassers and people protesting, that sort of thing, could be moved on by police, you will now need to go and change your risk assessment, because unless the protesters are blocking traffic or are being violent, burning things, making threats, that sort of thing, they cannot be moved on. As long as they are peacefully protesting, they are allowed to be inside the building, they are allowed to be on the street directly outside the building, provided they do not block traffic. Now, this means you will need to redo all your risk assessments. Risk assessments around traffic management plans, risk assessments around safety of parishioners, that sort of thing. You will now need to account for the fact that 50,000 people could be in or around your place of worship, and they are legally allowed to do that now. Now, given this is a very fresh law, I don't think SafeWork are going to go too hard on it at the moment, and it was only made last week, so the state has 28 days, I believe, to appeal this decision, where they can go to the Court of Appeal and have them have a look at it, basically. But for now, this is the ruling of the Supreme Court, that the police don't have the power to move these people. In any case, that's all I've got for you today. If you have any questions about that, because it is such a complicated issue, I would actually not suggest speaking to a work health safety officer, as they will have no idea what advice to give you. I would actually suggest speaking to a solicitor, because this is going to be a very complicated issue going forward about risk assessments and also about just how these places of worship will have to function generally now. Alright, that's it. Take care. Thank you.